We don't even know what these allegations are.
The first prayer is direct to high-level monitoring committee.
Unnumbered, unlisted application on behalf of a third party.
This doesn't get them anywhere.
Subject to curing of the defects, the say on the oral mention, an application in reputation numbers with a paper book of the unnumbered IE in reputation number 1216 of 2025 has been handed over in court. Say subject to curing of the defects, we register directly to list the application on the date fixed. The copies may be circulated to the party.
Very
That's fine.
But to them to file in the Congress.
great.
My lords, my lords, petitioner in person in item 1.5. I am grateful this honorable court has placed this
We have
order.
spent 1 hour in this matter now. Please spare us.
My lords, I did not get any chance. You just,
I think what all the issues have been broadly.
no, only 20 seconds. My lords, only 20 seconds.
May
I
I
am
add one
grateful
thing, Millet,
this
for
honorable
DCI?
court has placed this matter before a three-judge bench. My limited submission is that this raises a pure constitutional issue requiring independent consideration. My lords, the impugned enumeration form is not prescribed under the rules and therefore lacks authority of law to compel disclosure of personal data. This raises an Article 21 issue. This issue is not state specific and may kindly be recorded independently. I have a short note, my lords.
We will consider the point which you are raising is a very important constitutional issue and the constitutional liberty, private right to privacy, right to protection of data. We will examine in due course. ये elections से निपटने एक बार फिर करते हैं.
But this election also is very important, my lords, because this is a complete violation of constitution.
May
I want small short notes.
तो ये West Bengal का election सबके लिए headache हुआ हुआ है इसको.
But this is not state specific, my lords.
May
This is
The things are moving in the right direction in a very. You must have seen it now. Most of the issues have been resolved either through judicial intervention or amicably and with the mutual understanding of both sides. You are also helping us. Let us first see that the democratic process is peacefully over, and then the other issue which you are raising, we will consider in due course of time. So that we will not close your issues.
May I submit one thing? For election commission. 6th is the last date for nominations as per the schedule. And we need to come up with the final list by 6th evening or midnight, whatever. Because Millets, beyond that, no nominations can be accepted. Assuming that 7th, somebody could be cleared in terms of this adjudication, he can't contest, nor can he do anything with regard to that one. So good, my lords, for phase 1 Millets, 6th being the cutoff date, let it be listed 7th morning. We'll request the Honorable the Chief Justice to have the whole thing completed by 6th midnight or whatever the time.
7th,
Because we have to come up with the list by that date.
we have constitutional bench. 9.
That's why 4 o'clock.
Either we can list on 6th in the evening
6th evening, Millets.
or 6th at 4 p.m.
So be it. 6th evening. To take stock and to have
Because
the next course of action.
we can list even on 7th morning also. That will slightly delay our sitting of the 9th bench.
But complete picture could be before your lordships.
Then it will.
11th at 4.
Complete picture could be before your lordships by 7th morning.
Yes, otherwise election can't be held.
And the entire machinery to identify those 152 constituencies.
Yes, ma'am.
which
That we have been.
closing on
Yes.
6th.
6th.
So that all the logical discrepancies in those constituencies may be
Get finalized by the date.
because the other can.
They can
And
wait.
wait
Because
for
we
a
have got
couple-
up to 9th.
3 more days.
So be it. That's what we would like to bring to
Please
your
help
lordships'
the
notice.
Chief Justice, because
We do. We do.
neither the judicial officers nor the Chief Justice, without the assistance of the Election Commission machinery, won't be able to identify the parts and the constituencies which have to take.
The process is on, Millets. We'll represent to the Honorable Chief Justice there
Yes.
and see that that gets concluded by that
That
date.
gets concluded by 6th.
6th night.
And remainder can go up to 7th or 8th.
Yes, 7th, 8th.
8.
You are raising, that is answered by the statute.
Indeed, it's been answered by 23-3. Grateful, deeply obliged.
6th on 10th March 2020.
7.
He's passing an order in reference to.
Grateful, Minister.
Certain
Deeply.
directions were issued through a self-speaking order after taking notice of the disposal of objections by more than 500 judicial officers from the state of West Bengal, along with 200 officers from the states of Odisha and Jharkhand, to whom an extraordinary exercise of adjudicating the objections in the ongoing SIR in the state of West Bengal were entrusted. It was also resolved through that order, Honorable Chief Justice of the High Court at Calcutta was requested to identify some former Chief Justices, High Court justices, for the purpose of constitution of appellate tribunals, so that the orders adjudicating objections passed by these officers would be appealed by the aggrieved party before such tribunals. In addition, directions with respect to payment of honorarium from our traveling allowances and traveling, boarding and lodging, etc. for the judicial officers were also issued. After the order dated 10th March 2026, two communications have been received. We have received two communications from Honorable Chief Justice of the High Court at Calcutta. While Chief Justice के लेकर नहीं पहले वाला है. While new letter dated 21st March 2026 from our Chief Justice updated about the progress, updated the court disposal of objections by the judicial officers. Besides, the proposal to publish the first supplementary roll on 20th March 2026. Honorable Chief Justice also flagged certain issues in the said communication which have been addressed in due course of time. Next paragraph. There is another communication dated 31st March 2026, which we have received yesterday from Honorable Chief Justice of the High Court, informing that as on 31st March 2026, till 4:04 p.m., 46,60,135 number of objections have been decided in the entire state against the total pendency of 60,06,675. We are informed that by now the total disposal has closed 47 lakhs. 47 lakh 30,000. 47 lakh 30,000. 30,000. The DO letter further points out that on 20th March 2026, the Election Commission of India has notified constitution of 1919 appellate tribunals in this state. These appellate tribunals are headed by former Chief Justices, senior judges of the High Court. A team of representatives of the High Court from Election Commission of India and State of West Bengal, thereafter inspected, have visited various buildings in order to find out a suitable application for the appellate tribunals to function. Eventually, Dr. Shyama Prasad Mukherjee, National Institute of Water and Sanitation, which is an institute run by the Department of Drinking Water and Sanitation, Ministry of Jal Shakti, Government of India, has been was shortlisted. As we said, building was found ready to move accommodation, was found ready to move accommodation consisting of 21 chambers. We are informed by Sri Naidu Senior Counsel for the Election Commission of India that necessary permission from the Ministry of Jal Shakti has been obtained, and thus
For 8 weeks we obtained it. For 8 weeks to begin with.
for a period of initially for a period of 8 weeks, so that the tribunals become functional immediately. He further informed that the orientation stroke training to the members stroke presiding judges of the appellate tribunals will be undertaken today during the course of day, so that they are well conversed with the handling of the appeals which have been filed online stroke offline, so that they can conveniently handle the software where dealing with the appeals which have been filed online stroke offline. It goes without saying that the Election Commission of India will either seek further extension from the Ministry of Jal Shakti and or another alternative accommodation shall be identified in consultation with all the parties, in consultation with the parties. We have clarified that the appellate tribunals shall function at Kolkata. Next paragraph. As regard to the issue relating to non-availability of regions को comma में करना, regions, as pointed out by Lord Chief Justice in the above mentioned communication, Sri Naidu Senior Counsel for the Election Commission of India informs that the appellate tribunals will have access to the record, which was placed by the parties.
Yes,
Before the adjudicatory authority, namely the judicial officers. That it will be ensured that the members of the appellate tribunal have access to the said record for the purpose of deciding appeals that may be filed, one eye, by the persons whose names have been excluded from the voter list, two eye, or by the authorities of the Election Commission of India who might be aggrieved by inclusion of certain
inclusion.
Inclusion of the names in the revised inclusion of names by the adjudicatory authorities. Next paragraph.
That's
It goes without saying that the appellate tribunals will be
तो यही बात है क्या?
the appellate tribunal, or you see, in order to clarify, so in order to remove any sorts of doubts, we request the appellate tribunals to have full access to the records, records which were placed before the records of the judicial reports along with the regions assigned by the judicial officers while adjudicating the objections and decide the appeals that may be filed before them after apprising the parties with such reasons. After apprising the parties with such reasons. The appellate tribunals shall be at liberty to evolve their own procedure in accordance with principles of natural justice, and are requested to adjudicate the appeals that may be filed by the parties after giving them adequate opportunity of being filed. So, however, we entrust the appellate tribunals not to entertain fresh stroke new documents which were never the subject matter of adjudication before.
No, it has to be released. That will, if anybody wants to rely upon document, scheduled document, that should be considered.
Right. Not to confirm first documents unless without verification, without verifying their genuineness and authenticity.
Yes, fair enough, fair enough. That's good.
Document is necessary for adjudication of
Fair enough, that's fine.
parties. Of the parties. Next paragraph. The only other issue like by the Chief Justice of the High Court is regarding non-payment of honorarium. Honorarium along with travel, boarding and other incidental expenses. So in this regard, Sri Naidu and Senior Counsel for the Election Commission of India has placed on record a communication dated 25th March 2026 addressed to the Chief Electoral Officer West Bengal, directing him to release the necessary payments to the appellate tribunal, to the members of the appellate tribunal, the staff, etc., and to the staff, etc. So, in order to expedite the issue, we direct the Election Commission of India's top Chief Electoral Officer West Bengal to release the necessary, to make the necessary payment to the judicial officers and members of the appellate tribunal or other allied staff, if any,
Yes.
if any, in accordance with the recommendations made by Honorable Chief Justice of the High Court.
My lords may
The
consider. only
precedents
one
will have
thing,
for consideration of the proposed
that
nominees
new
that may be
documents
recorded.
issue may open a Pandora's box. Documents have been filed, they've been scrutinized. If there is any defect, that could be pointed out.
To leave it to the discretion of the appellate tribunal.
No,
That was in fact restricting the discretion of the appellate tribunal. If, let us say, an unimpeachable. Yes. Go under Article 227.
That could have been filed minutes when they had been given an opportunity.
This is surely not adversarial.
That's not an issue.
Why should CCI be concerned, Mala?
Yes, the whole process gets derailed.
Including voters.
No. ECI should not be bothered with that.
We only wanted the genuine voters to be there.
Yes,
No, of course.
Yeah.
not, we
When
are also want to see that
when
not.
ample opportunity was
genuine
given to
voters
file
are
your
not
document.
excluded.
You
That's
don't
why
find
High
the
Court
document.
Judge, Chief Secretary, all were
No,
excluded.
when ample time was given to file documents, you don't file. And no, you
The name
cry
of a
foul.
retired judge has been deleted.
Accepted documents which should be allowed to be placed.
Yes,
Investment in excluding people from voting.
very unfortunate.
Genuine voters who have voted.
Yes, that's why 45% is.
Hmm.
Genuine notice.
We'll see to that.
No, why the elections?
When it's appellate tribunal.
Michelle, they were issued after the last day.
The tribunal will know what to do.
All the other very chief justices, senior judges.
Election commission have done a very bad justice of the function.
What has been mechanically rejected will not be reopened then.
They will
On that.
All right.
We will give it to the tribunal.
Yes, my lord. Yes,
Discretion, whatever they.
yes.
That is, only precedence of consideration of the proposed nominees may be recorded, otherwise it will not be done. If it is done at the last moment, it's difficult for them to contest.
That the tribunal will take it into consideration that such document was not submitted earlier and there should be a justification as to why it is being submitted.
Chief Justices of High Court. These people cannot. It's no direction.
But when it tells that the new document is to be verified, that
By whom?
by issue
It is for
But
them to decide.
in the Indian National Congress nominated a candidate, the Mohtab Sheikh of Farakka constituency.
Please go and also we grant and it would be done. Election commission will take care of it.
Within the stipulated.
Only some precedence to this proposed nominees, that will expedite the
We
procedure.
leave to the tribunal, they will do everything.
But Chacha, how many proposed nominee of a recognized political party is in such a situation?
Maybe not a very big number, not a very big number.
We had 14, all are clear, all clear.
Let it be considered with precedence so that they can be on the fray.
Will assist the Chief Justice and his team to deal with all the logical discrepancies in
With-
constituencies going to
Yes.
poll.
Within the, my lord, we had 14, the 14s have been cleared.
No, maybe Indian National Congress has one.
Yes, yes, my lord.
Many have, not very.
Please
Not,
look
about not more than 10, not more than 10.
Chief Justice of the High Court has informed that the pending objections will most likely be adjudicated by 7th April 2026. So keeping the aforesaid date in mind, we approach this matter on 6th April at 4 p.m.
Deeply obliged.
Yes. Grateful, extremely grateful. Deeply Grateful, grateful.
Grateful.
My lords, only one sentence. My issue may kindly be recorded.
Your issue is definitely there, sir. You are there. We are also alive. Seven years completed under UAPA in Ranchi, and now it's been Delhi. It's time 7 years in custody.
But the learned ASG is appearing online. He may be unmuted for item 2.
10 years nearly is spent in custody. 2 orders of the Honorable High Court of Orissa. First, that the trial should end by December 23, and then that it should end by December 24. Have not been complied with. 25 witnesses out of 64 remain. 39 witnesses have taken 9 years.
Are you, madam, we hope that you are aware of the order which eventually we have succeeded in.
No, please, actually, this is what I want to say. If I can hand this over. Between December 2015 and January 2016, on the same allegations and on the same material, prosecutions in 3 different jurisdictions were launched: Delhi, Orissa, and Jharkhand. In Jharkhand, he was acquitted. In Delhi, he was convicted and sentenced to 7.5 years, which he has undergone. On the basis of the same material, there is a continuing prosecution in Orissa. If I can just hand this over.
No, what is, on 23rd March, of this very person we are dismissed.
No, that is the SLP against the Delhi High Court's conviction and sentence which he has already undergone. But on the same material.
No, we'll make sure that trial is concluded now in terms.
If I can then my lords, let my rejoinder come on record, because I've already filed a rejoinder. It was not been.
Counsel for the petition state that rejoinder has been filed. We will register directly to tag the same with the paper book. And now in terms of our order of constituting the courts which will hear on day-to-day basis, you tell us that within 3 months, why you will not conclude the trial? Post this matter on sources.
This is an ongoing case, so.
You filed the registry, you have said so, with economic.
Yes, we filed it because of the holidays, it's not come on record. So your lordship may give a short date?
Yes. We'll try to do this.
Item 3.
My lords, in item 3, day before yesterday, we moved an adjournment letter in the evening. Since yesterday was evening, it's not come on record.
Oh, who else is there in the family?
My lords, only the wife.
Where are you staying now?
But my lords, right now I'm staying in Madhya Pradesh, in a rented apartment. I've been complying with my lord's order.
You can be permitted to visit.
Let me seek instruction. My lords may have it next week.
My lords, they can also, if
let me verify.
My lords, they want, they can also verify the status.
In fact, there is one of the matters where medical bail was cancelled only because
the application seeks modification of the order dated 28th January 2026, whereby the applicant petitioner was released on bail, subject to the condition that he will not enter the state of the instant application has been put on the ground that the applicant's child, born on 17th February 2023, is in critical condition and has been diagnosed with ASD and ADHD. The child is getting treatment at AIMS Raipur in Chhattisgarh. It is stated at the bar that there is no other member in the family except the applicant's wife who can help the child for effective medical treatment. On this ground, the concession, a relaxation in the condition imposed by this court while releasing the petition of bail for my soul, then state council seeks and granted Monday. Certain the facts if so required. Meanwhile, the petitioner may be permitted to visit Raipur and consult the doctors on Monday, that is 6th. Or you can, today is Wednesday only, on Friday. Tell him on Friday, to visit his house and also consult the doctors in AIMS at Raipur.
My lords, in Raipur also, we are on the rented accommodation that the wife has taken. So I will be permitted to go there in Raipur.
So what we can do, it's not that you are
no, my lords.
You have been deputy director in mining.
Very well, my lords.
And allegations are that you mined enough.
I understand, my lords. Highly oppressed.
We have given note with it.
My lords, the good news is this is not a West Bengal matter. Well, as the Foreigners Tribunal matter, two brothers, your lordships had issued notice. In the case of one, this should have been heard together. We're just requesting a tagging, my lords. My lords, we're just handing over your lordship's order of notice, my lords. I'm very grateful, my lords. You've handed over? I'm grateful, my lords. I think there was some delay, my lords, in this.
Yeah, we issue notice for condemnation.
Yes, my lords. Condemnation of delay. Grateful, my lords. Very grateful.
Yes, my lord. Item 5, my lord. This is related to northeastern persons who are staying this site, my lord. Yes, my lord. That issue has been recommended to Attorney General, my lord. For the administrative side, Bej Barua committee has already given entire report, my lord. My issue is, my lord, that when even the investigation is conducted and charge sheet has been filed, the stipulated time frame is not being followed, my lord.
You may ask for the time-bound trial.
Yes, my lord. Yes, my lord.
That we can issue, but don't you think that...
No, only on this issue, my lord. Time-bound trial, my lord. Charge sheet has been filed, investigation conducted, 3 years, 4 years pending, my lord. Students go back in between, my lord. They are not here.
Say, in addition to what has been observed, so directed by this court, wide order dated 18th February 2026, passed in writ petition, criminal number 02/2026, in bracket Anup Prakash Awasthi was Tribunal and others, comma, it is stated by Shri Pradeep Railan, senior counsel for the petitioner that the specific relief sought in the instant petition pertains to time-bound conclusion of the trial arising out of FIR number so pending before
my lord, in Delhi court, so Rohini court, my lord, is there. One FIR is at Rohini court, my lord.
just give the exact, tell you
Exact, I will give, my lord. I will give exact number.
pending for the so court in New Delhi. So that trial pertains to an unfortunate incident of violence that led to killing of Udo Tania in Delhi in 2014. Having regard to the fact that the occurrence took place in more than 12 years, almost 12 years back, and after investigation, charge sheet has already been filed. So it seems to us that such like matters require prioritization and out of turn adjudication. Consequently, we dispose of this litigation without expressing any opinion on merits or on the allegations. With a request to Honorable Chief Justice of the Delhi High Court to consider such like issues on administrative side and take a holistic policy decision which may ensure a predictive timeline for adjudication of such like sensitive trials on out of turn basis. It goes without saying that the Honorable Chief Justice of the High Court or the Honorable Administrative Judge or the committee of the or the Administrative Committee of the High Court may, if deemed appropriate, issue administrative instructions to the presiding officer in the instant case for expeditious disposal of the trial.
May it please, Manoj. So this is a petition which, the contempt petition, looking at order of 16th September 2011, which is page 15. Now, I must say in fairness that your lordships have in Atmalinga Reddy said that when there is a bar in the constitution and in the River Disputes Act, individuals shouldn't actually come to the court with this. But in that, it was an Article 32 petition by somebody dealing with the inter-river water dispute. Two distinctions is one, this is not regarding the water dispute itself, it's regarding the contempt of this court.
This is another species of the water dispute.
No, it's happened before, my lords. I just want to, in fairness, say that your lordships have said that 32 petitions anyway are not maintainable. Mine is only limited.
Contempt. There is no contempt.
There is a decision that they have taken, which is at page 1348.
The Almaty Dam
Yes.
is a part of the order dated 30, or the award dated 30/12 to the interim direction of the tribunal,
Yes.
dated 30/12/2010,
Yes.
which was not stayed.
No.
What was stayed?
No, it was effectively stayed because what happens is the minute your lordship says report will not be published, that means it's a stay under the section.
Please come, Mr. Gopal.
Page 16.
Order.
Page
In our
16, last
opinion,
line.
There is no justification to stay decision dated 30/12/2010.
That's correct. That's correct.
So, 30/12/2010 actually is the order on the basis of which the dam height is being increased.
Correct.
Thereafter, what happened was, on that interim order, there were references by the various riparian states.
Can I draw your lordship's attention? Last line of that order. Last line.
Correct.
That last line says, we direct that till further orders, the decision which may be taken by the tribunal of the reference petitions shall not be published in the official gazette.
You're absolutely right. That is the 2013 decision.
Correct.
It is not the 2010 to 2010 decision.
Then your lordships are effectively saying that there is a license to go up to 524. That's not the understanding of the states at all. Because 13 comes after this order as a final order, and because it can't be published.
When 13 comes, the writ petition was filed, and an injunction was on the publication. But it is not staying the 30/12/2010 order.
May I just show your lordships the section from the Act, because section 6 has that impact. Give it to me first. Yes. Section 6 says the central government shall publish the decision of the tribunal in the gazette, and the decision shall be final and binding on the parties to the dispute and shall be given effect by them. 2 says the decision of the tribunal after its publication in the official gazette shall have the same force as an order or decree of the Supreme Court. Now, without a section 6, there is no question of implementing or giving effect to the decision.
Look at this in this way.
Yes.
So there is no injunction.
Yes.
In terms of the order passed by us.
Yes.
In not raising the dam's height. Just consider this. The way you argue, the answer comes from there.
I think I will just withdraw, my lords. I don't want to invite your lordships to give me an order more damaging than the one that I think exists.
Correct. Not a case of you're coming circuitously through and in the contempt.
No,
you have to
because we believe that increase from my lords, our understanding for 16 years, all of us, all states, is that 519 to 524 is not permitted at the moment. Now,
we are not saying anything.
Yes.
We are looking at it from the narrow compass of contempt.
Very well, very well. In which case, I will not press this, my lords. Just allow me to withdraw it.
Can you stop us straight from when you intervene,
I'm grateful.
Please, your lordship. Sir, custody matter, lords. I'm here with a small prayer, lords. The expeditious disposal of the special appeal, which is pending.
I think we have to direct the register now not to entertain the
Lords, Lords, may just see page 86 for a moment, lords. The matter was last taken up on 18th of July, lords. on 20th, an FIR was filed against the mother, my lords.
So advise me approve the High Court.
Please, my lord, I am appearing item number 8. I have filed an adjournment application and circulated it. I have
Yes, actually, adjournment later.
There is no letter circulated.
the AR has circulated the letter, my lords.
No, we have not received any letter. You might have circulated in your office.
My lords, I seek a week adjournment. The arguing counsel is facing some difficulty today. Therefore, I seek a 1 week's adjournment.
No, why should we grant adjournment? We have read the brief. This is not the way to argue in court number 1. You force us to read the brief and then you say you had circulated letter. There is no letter circulated.
My lords, then I will clarify it with the AO, if my lord may pass over it.
Why pass over? You are there, you argue it, please.
My lords, the arguing, I have not gone through the brief. The arguing counsel is facing some difficulty in this matter.
What is the difficulty? We can't understand. You decide while sitting at home, there is a difficulty in the senior counsel and therefore court must accommodate you. The adjournment is sought without it claimed that a letter was circulated, a letter for adjournment was circulated, which is not on the record. When the case is called coma, it is again stated that some senior counsel is to argue, who is not presently available. Post this matter on contact.
Please, my lords.
When did you go to those matters? 6th. So simply adjourn to 6th.
6th April, your lordship may post, my lord.
We are adjourning on 6th so that all matters can be taken together.
Very well.
Like, my lords.
I'm requesting for a passover, my lords. I'm being led. My lords, I'm requesting for a passover, my lords. I'm led by Mr. Balbir Singh, senior advocate.
Who is to argue?
Plus Mr. Balbir Singh, senior advocate. He's on his legs in for 2 minutes.
Okay.
The respondent, Commission for Equality Management. The Commission for Equality Management, respondent number, the main respondent over here, R2, R1.
Are you for CAQ1?
Yes, I'm for CAQM. Sorry, I was saying the whole. I was giving the whole name instead of saying CAQM.
You are more familiar with
Yes, I'm appearing for CAQM. I'm sorry.
CAQM looks to be a very impressive name, as if you will do something about pollution. We don't know whether you will do or not.
Lordship, I think CAQM has really been working very hard. It's just that, at least in the pollution matter, there are too many other circumstances which kind of have a huge role to play.
Can we take up some on further date? Post there are arguing counsel is not available. Post this matter for hearing on something.
Is your Lordship giving a date?
Yes.
Lordships. Grateful, my lords. Gratefully, Lordships, obliged.
My lords, interim relief restraining the respondents from creating third party is granted in 2014. And my lord, since that the petition are pending at the stage of admission. The petitioners are the bona fide purchasers. If your lordships may kindly see page 1.
That is a plea will be examined by
all my concern is, my lords, the matter is now, I have filed an application seeking.
Date probably.
My lords, the next date is on 8th. So at least if your lordships would direct to consider the application.
Has to direct the High Court.
My lords, my concern since last 1 year.
The High Court is already seized of the matter for final adjudication. And case is now listed on 8th April 2026. We see no reason to undertake this special petition. The petitioner shall be at liberty to raise all contention before the High Court at the time of final hearing.
My lords, may I mention, I have already mentioned the matter for many times, and on one date, my lords, it was specific.
Once you will show this order, probably High Court will put up.
My lords, I'm only requesting if your lordships may kindly observe that to expedite the at least hearing of this petition, because since last 12 years, my lords, the petitions are pending.
Will you please go there with this order? We have no reason to doubt.
But I'm requesting just to observe with the to expedite the
Item 12.
Kindly have the photograph, page 36. The entire land is released. My lords, the surrounding area, my lords, which I have shown, entire area stands released, my lords. My lords, may kindly also have the reply of the state that they have filed. Kindly have the reply that state has, my lords, I know, my lords, there are two things, my lords, I wish to make submission on, my lords. My lords, the entire surrounding area is released, my lords. It is abutting the Abadi, my lords. My lords will see page 36, my lords. That's why, my lords, I have asked them to give a photograph of the surrounding area, my lords. Entire village, my lords, the land was released by the under sections 5A, my lords.
Where is the question of this fraudulent provision of 101A?
But the policy of the state government.
Why it has not been struck down so far?
My lords, the issue of discrimination has not been considered. I am on issue of discrimination, my lords, not on 101A, my lords. The issue of discrimination has to be considered by someone. My lords, what the Honorable High Court says is, my lords, in this 491 acres or section 4 notification, my lords, award passed 230. After award, 75 more released. Only 150 acres is actually acquired, my lords. Now, my lords, in the reply, they say, my lords, that the land which was required for Metro Depot has already been taken. I have not even filed for that. Only the land on which my houses are constructed, which is abutting the Abadi, my lords, for that, my lords, this case has been filed, my lords. My lords, we consider the photographs and the plight of these people, my lords. This is their only house in which they are staying. My lords, the issue of discrimination court says that it was decided earlier. It has never been considered. My lords will have the earlier orders. My lords, the issue of discrimination is not gone into by any of the courts. My lords will see only 2 pages, my lords, with respectful submission, my lords. Page 67, my lords, which is a chart of, my lords, how the land has been released by the state government, my lords.
You are not challenging those released before us.
My lords, I am seeking parity. I am seeking parity, my lord. Discrimination. Where is the question of parity? My lord, this honorable court has time and again held, my lords, in 2010 also, my lord, Jagdish and all those judgment, my lords, Sports City, my lords, they have said, my lords, that in discrimination has to be seen from that angle, my lords. If similarly situated landowners' land has been released, my lords, here, my lords, will see, my lords, may kindly have page 57. How they have gone about the acquisition. In village Islampur, section 4, 113 acres, section 6, 98 acres, area released before about 19 acres. Thereafter, my lords, it only comes down to 51 acres has been released, my lords. After in totality, only 60 acres has been acquired. In total, the acquisition 491 acres acquisition, my lords, only 160 acres is acquired. Well, this issue has to be gone into by someone, my lords, whether I was similarly placed with them or not, my lords. From the photographs, I can show, my lords, that the land which has been released,
is abutting those lands which have been released by the honorable by the government, my lord, under section 5A. My lord will see the site plan also. My lords, I am surrounded on 3 sides by released lands. My lord, it is not that these people, my lord, these people.
Question for the petitions, we do not find any ground to interfere with the informed judgment of the High Court, especially the accordingly dismissed. However, keeping in the particular factual circumstances of the case, there are 10 of the impugned judgment to the extent of imposing cost of rupees 25,000.
My lord, these people will be left without house, my lord, because of inaction of the state government and, my lord, the complete discriminative practice being adopted by them, my lord.
Very good, very good. You also ask someone to challenge it.
Please, my lord.
Please, my lords.
Your right.
I'm praying for a time-bound disposal, my lords, because the tenure, my lords, of the House that terminates in early 2020.
Because the Chief Justice of the High Court.
My lords, the problem is, my lords,
if the Supreme Court
I could draw a little bit of sustenance from your lordship's order, my lords, of 2020, my lords.
That's right. So that means, despite our orders, we are not hearing it. Then do you think what should we do?
Well, the similarity went to such an extent that the Honorable High Court was also the same, my lords.
Go and apply the.
My lords, if I may, my lords. Otherwise, my lords, what is happening is, my lords, what is happening is, my lords, that they are taking dates. It is being listed every day, my lords, with great respect.
Honorable Chief Justice of the High Court of Manipur, with liberty of ordinance and disposal.
Grateful.
I beg to pay, my lord, on behalf of the petitioner, my lord. Is a tender taken out by Central Coalfields, my lord. Now, my lord, the clause in the tender in relation to additional performance security was in question in the first round of litigation because there was some lack of clarity. The High Court said, my lord, you have to do it. My lord, Caliber, who was the successful tenderer, came before this court, my lord. This court said, no, there is some
matter is pending before the High Court.
I know.
Contention you have, go and try there.
Let me explain, my lord.
So this was a writ petition which should have been dismissed by the High Court on the very first date. Unfortunately, notice has been issued, therefore go and argue.
No, my lord, let me explain, my lord.
You are blacklisting the system. You don't want to pay anything because you are successful bidder.
Not like this, my lord. Let me explain for a minute, my lord. If your lordship.
No, why should we entertain, Mr.
My lord, may I just explain, my lord? Serious prejudice is cost to me. I'll tell your lordships why, my lord. The debarment, my lord. Just give me a minute, my lord.
No, then we will impose cost on him. Then we will impose equivalent cost of the.
It's a blacklisting, my lord. It's blacklisting. My lord, I have not been able to participate in other tenders. My lord, I can understand. My lord, CCL tenders, my lord.
Mr. Beck,
CCL tenders, I can understand.
how can you dispute the logic given by the High Court? That if we injunct the blacklisting order, we are putting the final relief at this stage.
My lord, I will just answer that question.
The order was very clear.
Can I just answer your lordship's question?
Why should we go and answer to the?
I'm not saying, my lord, that the blacklisting, my lord,
These
was
people can afford litigation because at sometime, unfortunately, they get bumper dry litigation. This is how people are encouraged to file frivolous and most dishonest litigation.
Lord, can I just answer your lordship's question, my lord? My lord, the CCL debarment order is limited to CCL. But the problem is I'm not able to participate in other tenders of the PSUs, my lord, because, my lord, each one of them has this clause.
They have an interrelated clause.
Correct.
That
Every other PSU
blacklist, you are out.
Not from every tender. That's the predicament I'm facing and the prejudice I'm facing, my lord. So it's
just see the principles of injunction. Let us say in such a situation, it is found that the blacklisting was illegal, egregious. The compensation by way of money is available, even as a constitutional law.
Today, my lord, I'm not able to participate, my lord. I have 20.
That is what we say, that if the compensation will be subjected to a cost.
Compensation may not be an adequate remedy, my lord. Can I just, my lord, request your lordship, my lord, the matter is posted, my lord. Would your lordship, my lord, request the High Court to take it up and, my lord, dispose it of?
We will not say anything.
I'm sorry, my lord.
No, we can't say, Mr. You go and tell the High Court.
Just the point that has no bearing.
That 11th August Supreme Court order has no bearing on the present matter. That was a different issue altogether. At least to that extent, lordships can clarify, my lord. At least to that extent, my lord, some clarification may be.
We will not say anything to the absolute prerogative of the High Court to hear.
Very good.
Lordship, we've circulated a letter in item 15, Lordship. After a week, Lordship.
We'll give a date now that after reading the brief, you circulated the letter. Anyway, we have We'll give it after 1 week you want.
Lordship.
We'll give it.
Lordship, there's one more request. There are two more matters arising from the same impugned order. Unfortunately, they are not numbered. So can I just give the details?
The number. They must not have been numbered. Are the defects cured?
Lordship, we are in the process of doing it.
When you will cure the defect, number will be allotted.
Lordship.
Once you cure the defect,
Lordship.
then number is bound to be allotted.
Lordship.
Don't blame the registry for
No, Lordship, I'm saying something else. Let these two matters also be listed.
We can, but first you have to cure the defect.
Will do.
Once you cure the defect, then please make a mention to us.
Lordship.
Or tell the registrar, he will tag the mention.
Lordship, please. Deeply obliged.
But first do your job.
Lordship.
My lord. My lord, the present petition is about the tragic incident which happened with Air India 787 Boeing.
People file this kind of petition. What is your deep-rooted agenda?
Lordship.
The people who unfortunately lost their life, their families are not coming.
Lordship, because
nobody else, those who are directly having grievance, they are not coming before any form.
Because Lordship, it's about public safety only.
No other work, you start filing PIL. As if we don't understand what is the motive.
Lordship, it's not about motive, it is the petitioner is.
Please don't compel us to observe something more.
Lordship, may direct the respondent to consider my
We
representation.
will not say anything. First you go and tell them.
Yes, Lordship, I approach that.
Very good. If you have done your duty, good enough.
This much may be, Lordship.
Thank you.
Direct the respondent to consider my representation, which I gave them, which is part of petition. This much.
All right. Don't compel us to make any adverse comment. Item 17.
So I appear for the petition. So admittedly, the construction is unauthorized. Kindly see page 156. Page 156. The affidavit filed by the municipal corporation.
No, but I think High Court is right, Mr. Nabde. You can. When did you file this petition?
So I do accept that there is some delay. The question is this: whether something which is patently illegal, does it create rights?
Mr. Nabde, in 2019, you come in a writ petition telling that something illegal has happened. That illegality partly cured by imposing penalty of 101 crore in 2011 and 12. People must have been, how many apartments are there?
So the point is this.
No, please tell us how many apartments are there.
So there are a large number of apartments. I am not on that.
How many families have been settled there? No, you see the drastic consequences.
The point is this.
The builder must have run away from the scene after selling these apartments.
Therefore, your lordship sees that the rich and the powerful can defy the law of the land and then say rights are created. Now, kindly see one more thing.
Rights in whom? Rights not in builder. Rights in the home buyers. Who must have spent the entire life saving.
There is no right of inheritance of an illegal act. Nobody. So kindly see, the time has now come. Consistently we have seen.
Please tell us, if the petitioner is so conscious keeper of the society, what prevented him to approach court on time?
Consistently we have seen that the builders defy the law of the land and then
take action. Builder, we don't spare every day. We are taking the
what is happening here? Nobody is taking any action.
You allowed the
builders go scot-free. So there is one more thing which I want to show to you.
The bona fide becomes highly doubtful of this kind of person. You allow something to happen in your front of your eyes. The building is raised.
That's not the finding of the High Court.
Innocent
That's not the finding of the High Court.
It is on record. It is on record.
That there is a delay. That I am not disputing for a moment.
What is
but kindly see, my lord, consistently take, for example, there is no environment clearance.
And fortunately for you, the other matter where the larger issues are pending, you go and join those proceedings.
So the question is very simple. There is no environmental clearance.
So this is after that, 5th January.
So kindly turn to page 372.
He followed your submission, sir.
The problem which arises is over.
So with respect, Mulot, this is the new jurisprudence.
Over 600 home buyers.
That the new jurisprudence which the court is propounding is this, that a person may commit an illegal act and somebody who derives benefit of that.
Mr.
No illegality is attached to it.
Very attractive argument. Who will compensate them? Who will compensate these families? Please tell. None of them members. No, you don't implicate the party. You want. We do not know what is the target and whom, at whose instance this kind of so-called PIL is filed.
When the public
don't implicate the persons whose they might have spent their entire life saving there in filing. 600 families are there. You can't implicate them.
There is a consumer fora. They have ample remedies.
Wonderful. You want us to now declare it so illegal? They will go to consumer court.
Look at the history of this matter. Look at the history of this matter. First, plots are allotted, violating the policy. The matter comes to your lordship. Your lordship say that now that the plots are allotted, construction is carried out. Now, this is what I'm saying. This kind of jurisprudence.
What prevented you the day some building plans were submitted?
It takes some time because all this is not easily accessible to public.
Mr. Nabde, first of all, what prevented you to approach the court the moment building plans were sanctioned or any construction? This construction can't be made in one night or in 1 month or
kindly see
1 year.
Kindly see 2 documents which I would like to show to your lordship. Kindly see.
Unfortunately, failed to comply. That is what you are pointing out.
So I wish to point out to your lordship, kindly turn to page 372. The area which was kept to be green is also constructed upon. Now, to what extent the courts are going to tolerate this? There is no law in this country which can be easily defined and then come to the court and say third-party rights are created. This has to stop somewhere, sir. We are sending a wrong message to the community that this country there is lawlessness. And people can get away with impunity.
When somebody comes on time, we do it before creating the. It's not a.
In other words, there is a law of limitation for illegality. What was patently illegal becomes legal.
There is no law of limitation.
So this is strange logic, sir.
Today you want to, 600 families you want to be thrown out of a building which, as you may be right in saying, it was illegal.
That may be the unfortunate part. The courts can take cognizance of that and grant appropriate reliefs to them. The point is that court cannot put its imprimatur on an illegality. That's the point, my lord.
Yes.
I can't place it any higher than this, my lord.
We have heard Sri Nabdul and Senior Counsel for the petition at a considerable length. We see no ground to interfere with the informed judgment of the High Court. 14th November 2025, primarily for the reason that the alleged illegalities took place in the year 2011-12. Before 2011-12, instead the building was completed by 2011-12, and the builder from developer is stated to have paid a penalty of 101 crore towards regularization. Except now 600 families, home buyers are occupying the building. Just to ensure circumstances, the High Court drew balance in not entertaining the PIL amendments.
Grateful.
May it please your lordship, this matter has reached a stage of where they.
But now I think case is fixed before the argument.
Well, yes. Fixed for argument. There's one issue only, Malaj. We've received the reports, etc. All the volumes of the reports.
They filed objections.
So all
they filed their objections before the High Court.
My learned friend will let me tell the court everything. We file preliminary objections, and why we are before your lordships is because your lordships had directed the videography would be done, and it's important because the presence of our side, their side, etc., will all be established. There are some issues that have arisen. We've made some objections, those objections have not been heard and so on during the process of the survey. All we need is the videography to be handed over and color pictures so that we can make our objections to be substantive to the extent possible. Well, that's all we are seeking. There's no need for such haste that this can't be given and whatever extra week or whatever is required for us to give further objections. That's all we.
Sir, that it can't be given. So the only order is that application along with main case to be taken up.
Because that's all. The problem really is that when the main case is heard and our objections are not there because we've not looked at the videography. That's the only thing. And heavens don't fall, my lords, if in a week's time we are given all these documents and the court could then hear it after a week or whatever week, 10 days. That's all we are seeking. Well, nothing unreasonable, no intention to delay it in any form and so on. Well, there are two issues. Your lordships will just look at the page 5 of the order. Internal page 3, there's about the 4th paragraph there. Also heard IA 2318 of 2026, which is an application filed on behalf of Respondent 8 for production of video recording and colored photographs of the survey. The aforesaid IA shall be considered at the time of the hearing of the petition. Well, the hearing of the petition will be too late for us at that point to point out to anything as far as the videography is concerned. The issue of maintainability, they can decide at the time of the petition being taken up. Well, that's the previous IA. Previous paragraph, your lordship will see also heard IA number 2317, which is an application filed on behalf of Respondent 8 for dismissal of petition being not maintainable in the eyes of law. This they could take up as the lordships would normally take up something for maintainability before the substantive matter is taken up. But the videography issue is very critical, my lords.
If lordships permit, may I just...
What objection possibly against videography?
We filed subject to getting the videography, my lords. We filed whatever objections we could file at this stage, but they cannot be comprehensive objections unless we know that issues that were arising during the...
Was the videography not done in your presence?
It wasn't. My lords, that is the issue. It was to be done in our presence, but unfortunately, they were doing the survey in 4 places at the same time, and only 2 people were allowed, and we couldn't be everywhere. That's the issue which videography would confirm.
Obviously, in such like matters, only limited persons can be allowed in the...
Certainly, my lord, certainly.
Otherwise, you see...
It become a... Yes.
Manageable crowd.
Absolutely, certainly.
It become very difficult. But because we are quite sure that in compliance to our earlier order, they must have provided you representation at the time of videography also.
Yes.
Now, you still may have some objections against videography. So we request the High Court to decide those objections.
I'll tell them.
Please, paragraph 6 of your application for the videography, 544.
544, that's right.
Paragraph 6. That actually, to our understanding, crystallizes the case that why you need the videography.
May I just read that, Wallace?
Yes.
Paragraph 5, your lordship, paragraph 5. That from the above table, it is crystal clear that there are several objections in the manner in which the survey was conducted. The process was incorrect and erroneous in nature, therefore, to demonstrate that the actual situation and also to demonstrate the malafide of the ASI, the videography of the survey is essential. that it is noteworthy to mention here that the objection raised by respondent number 8 was duly recorded in the videography. Further, there is no mention of any of the objects in the survey report which demonstrate the malafide of the ASI. Well, so this
is the nub of your issue.
I'm grateful.
A survey report puts in, let us say, 1, 2, 3, 4, 5 objection, but according to you, there is 6, 7, 8 objections which do not find place in the survey report. But if one sees the videography, your representative in all probability would be seen
grateful
to be raising that.
Could be established, and this could be done very easily.
If that is the area of concern.
Well, it's one area of concern.
When the report is accepted, during the hearing, the report is being accepted, and this issue you have flagged, the videography will be played in court, and the parties would be at liberty to make appropriate comments with regard to the acceptability, correctness, etc. of the survey report in relation to the content.
I'm
grateful. I'm really grateful.
And my lord, the impugned order, my lord, records your lordship's direction. Parties may submit their respect to the Honorable High Court records, my lord, objections, opinions, suggestions, or recommendations in respect of the report of Archaeological Survey of India before the next day, if not already filed, in terms of the directions contained in para 9, subpara 2 and 3 of the order dated 22nd January 2006 of your lordships. So Honorable High Court has taken care of, and the last hearing.
Your order said that
yes,
survey report shall be made available.
Correct.
And what Dr. Khurshid is flagging is the report will include all documents, electronic evidence or documentary evidence annexing or accompanying the report.
Correct.
And even if you see Order 26, Rule 10,
correct,
if both parties are entitled to not only the report but also
the High Court has not
evidence collected by the.
Lords, may I submit the High Court? May I submit, my lords, the High Court, lordship, may kindly see page 5, has not rejected the report, which has rejected the request which has been raised by my learned senior. High Court has only said that we'll see it at the time of final hearing. We are also entitled for. I'm so sorry.
In fact, this petition, my lord, is premature. In fact, the Honorable High Court will consider every objection raised by them.
It is listed tomorrow for final hearing.
Yes.
They have filed their objections of 499 pages. Objections have already been filed. We are also entitled for copy of the colored photographs and videography. We will also be requesting at the time of final hearing. My learned senior will also be.
Certainly, my learned friend should have it. We should have it. I'm only raising the issue that if we could get this and the matter was taken up after a week, we would have comprehensive objections if there are any objections.
State tomorrow.
Well, it's one of the issues.
Let High Court take cognizance of this.
Because one of the issue that is the reason was that your lordships had said no excavation will happen. Now, our objection is that excavations did happen. Now, if excavation happened, the videography is there, then the whole picture changes. Well, that's the only reason. Heavens don't fall in a week's time if we are given this material. Both of us look at the material and then a comprehensive objection is placed before the High Court.
Lordships permit.
Now just come to parent 8 of our previous order of January 22.
Yes.
On our suggestions, Sri Salman Procedural and Senior Counsel for the appellant clearly submitted that a copy of the survey report may be ordered to be supplied to the party, and thereafter the appellant may be permitted to submit the objection.
Which?
That survey report has been given.
Yes.
Such like liberty can also be granted to the other side. These objections thereafter may be considered by the division bench of the High Court at the time of final hearing.
Correct.
Probably that is what the High Court is following.
Correct. Well, the High Court will do this. We have no issue there at all. But we would be at a great disadvantage if we have some objections that would emanate from the videography. We would not be able to put that before the High Court. And it will seem almost like an afterthought that we are now trying to add something more. Whereas we go comprehensively to the High Court, in a week from now, all this will be available. If we don't have a case, we don't have a case. The High Court will finally decide, of course.
This request can only can be made to the High Court. It's listed tomorrow.
Yes.
Matter is listed tomorrow, my lord.
This request
Can be made
and High Court has not rejected the request.
to both the parties.
High Court has not rejected the request.
And in fact, in the previous ballot order, all these objections were raised by them, and your lawsuits considered that pass this order. In Melot, the Kamaluddin Welfare Society, Dhar MP versus Hindu Front for Justice ballot, in that matter, and that is quoted in the impugned judgment order.
Lordship may kindly appreciate.
Keeping in view your lawsuit's direction, ballot, the hearing has to take place tomorrow before the Honorable High Court.
I only ask myself if it could be done effectively and objectively in a week's time with the information and material available to both sides.
So what is probably can be done, that you, as my brother has pointed out, page 544, you are saying that during the course of videography, you raise certain objections.
Please, Bala.
Objections, according to you, are there part of the videography itself.
Quite right.
So we request the High Court to watch the videograph recording, and whatever objection has been raised, that must be dealt with.
Considered.
That must be dealt with.
I could take care of it tomorrow.
That is to
Well, that's one way. That's one way to proceed.
That I think
That's it's fair, Malad. It's only fair as long as the High Court is conscious that it needs to address this issue, and then the High Court will decide itself whether it should proceed or not.
if the High Court, maybe that we all know the High Court will hear both sides on those objections.
Absolutely, sir.
Take a call. Appeal number so-and-so that had arisen against an interim order dated 11/3/2024 passed by the High Court of Madhya Pradesh, disposed of by this court on January 22, 2026. After hearing both sides, is in the order. In parallel to the said order, this court took notice of our request and taken on behalf of the appellants that a copy of the survey report may be supplied to the parties and some time may be granted to them to submit their objections. And such objection then may be considered by the division bench of the High Court at the time of entry. Consequently, the directions contained in para 9 of the aforestated order, a following directions contained in para 9 of the aforesaid order were issued. Next paragraph. It seems that there is no dispute that the survey report was supplied. The survey report was supplied, and some of the parties have submitted their objections against the same. It further appears that the Archaeological Survey of India also conducted videography of the site, and during the course of such videography, the appellant, raised certain objections. Next paragraph. The High Court has now, in deference to paragraph of the order dated 22nd January 2026, passed the interlocutory order to the effect that the objections submitted by the parties shall be considered and decided at the time of final hearing.
Therefore, production of the video record and photo.
Directed that the application filed by the appellant for production of video recording and colored photographs of the survey shall be considered at the time of final hearing of the case. Next program. In this regard, we may take notice of para 6 of para 5 and 6 of the application moved by the appellant in bracket who is respondent 8 before the High Court. This is for page 543 and 544. Next paragraph. It thus seems that the appellant raised certain objections. It thus seems that according to the appellant, he raised some objections which are duly recorded in the course of videography. Also, we have no reason to doubt that the Learned High Court will, after seeing the videography, consider those objections too, along with other objections made by the party, in accordance with principles of natural justice, and take an appropriate decision. On such objections, on the objections, including those which are found recorded in the course of videography.
Please, Vilas.
I think that would next progress. In this regard, we have not made any, we have not expressed anything on the matter. All the issues are left open to be adjudicated by the petition. The parties may accordingly submit their respective claims before the High Court.
There was a direction that the petition may be decided within 3 weeks. So that's recorded in the previous order of my lord. That may be.
That's why we are referred to our order of 22nd January. High Court seems to be rightly so because we have used that word in para 8. If the objections can be nowadays, one is physical objection, you can file in writing. The other can be oral objection, which sometimes the court will not entertain because unless there is substance. But video recording is also a form of now, and under the New Evidence Act and the videography is also permissible. So if there are objections there, we are quite sure the High Court. We have requested the High Court to decide those objections as well.
Well, there's just one issue that the objection may not itself be recorded in the videography, but the videography may show something which relates to the objections that we have submitted. So if it's not taken to be too restrictive, that your objections are not
recorded in the videography and or the objections sought to be inferred from the contents of the video.
I'm grateful. I'm deeply grateful, Malad.
Please, my lords. My lords, in item 19, we've received the report of the SIT. I'm just the seal cover. I apologize. We weren't able to file it because of the holidays. We weren't able to file the report because of the holidays, the SIT report, my lords. We usually file it.
The SIT?
Yes, my lords. So, my lords, there's a seal cover report.
What do they say?
My lords, effectively, there are 2 points that my lords had. I'm sorry. There were 2 issues, my lords, that were there before the SIT. The first was the issue of collusion. The second was the issue of disproportionate assets of these 12 identified officers. On collusion, my lords will see they have found something. They have found certain money trails. They're there in the first part of the report. My lords may see that. On collusion, my lords, they have found something. My lords may see that. My lords may see the first part of the part 1 of the report, issue number 1. There are certain curious, disturbing patterns that have come out because they had to map 169 accounts of the beneficiaries with 75 accounts of the 12 officers. 60 accounts have been mapped, 15 accounts still remain to be mapped because it's 169 and 75. They've discovered something, my lords. My lords may see that. On the issue of disproportionate assets, my lords, it is a very time-consuming effort because even when CBI does inquiries on this, for one person it takes at least 6 months. Here it is 12 persons, and my lords may see towards the end what all they have done. They've got all the service details. They've got all the property details. They've got all the, apart from 15 bank statements, they've got these 60 bank statements of these officers. They've got the insurance policies. But now with respect to their actual assets, they've got them from Noida, but they haven't got them from DDA and Greater Noida. So they've asked them. Separately, many assets that people invest in are in by private builders. So they've written to various, because authorities themselves, like the DDA or the Noida authority, may not know who has invested in some land project, etc. So they're getting these details. They've got, I'm sorry, they've got all the salary details. The asset declaration is what is, they have examined everybody. One of the officers is no more. There's only 11 officers left of the 12 identified officers. They've examined all of them, but certain ends are left to be tied in disproportionate assets. My lords may see it's a very, very detailed process, which is taking, unfortunately, some time, because there are 12 officers and their family members and their accounts. And of course, these transactions mostly happen, they don't always happen through bank accounts. The other thing, my lords, that the problem that is arising is that two banks have merged with, one has merged with Punjab Bank, one has merged with Indian Bank. And these transactions are of 2016, etc. So if my lords may see, they have also annexed some of the bank account statements where they show that when the money would come in, immediately 10% would go away. And it would go away in the bank statements is written as per details. So to get those details, they have to get the voucher from the bank. So that is what they have applied for. And these transactions are of 2016, 2017. Some banks, because the bank has merged now, I believe the Oriental Bank of Commerce has now merged with Punjab National Bank. So they don't even have those details. So it's a very difficult and very tremendous exercise that they're all undertaking, my lords. My lords may just see that. But collusion, they have found something. The other thing, my lords, is taking more time than was expected.
No, ultimate, what is their conclusion and intention?
I'm sorry, my lords?
What is the conclusion finally they have drawn?
So, my lords, the conclusion is that they still need to verify certain things.
How much time you need?
My lords, they've asked for 2 months. My lords may give, this time I have personally spoken to the chairman of the SIT, and he's personally requested, because they're very close.
Only in court, and we don't say the SIT constituted under the orders of this court has submitted a supplementary status report in purported compliance of our order dated 21st January 2026. The report contains various factual issues, the SIT as with respect to the incomplete conclusions seeks 2 months more time.
You said 2 months.
Hmm?
You said 2 months. Oh, I'm sorry.
2 months more time for completion of the ongoing investigation stroke inquiry. So with a view to enable the SIT to complete the entrusted task,
You have to ask the court to provide the petitioner with the copy of the SIT.
we grant 6 weeks more time to complete the ongoing process and submit a final report. The question whether copies of the supplementary status report is to be supplied to the person likely to be affected or not shall be decided at the appropriate stage. Shall be decided at the appropriate stage. The registry directed, the court master directed to receive the report and send it at the the residential offices of at our residential offices. For example,
I'm very,
post this matter after 6 weeks on so date. 6 weeks.
no, I'm very grateful.
Grateful. Plus, may I have your lordship's indulgence in this item 19? Your lordship said in January directed that my representation would be considered by the SIT, Lord, which I made a representation. So I just wanted, Lord, the direction from lordships, Lord, that they may let us know, Lord, what is the decision taken on my representation.
I'll convey that. My lords,
find out.
Yes, lords, one more issue that the SIT is facing, even though my lords had earlier passed an order saying that nothing will happen against the farmers, and we keep assuring them, but they are giving a lot of reluctance in coming for giving statements or naming people because they are concerned that they will be roped in. And my lords had clearly written an order 2 years ago saying that no FIR will be against the farmers. If my lords may just, because we are trying to reassure them.
That paint a negative picture about you, that you are unable to win over the trust and faith of the people despite our protection. Look at the image of the police.
My lords, we are to do it.
Why we will put it like this.
My lords, we'll
tell them be little more human.
Yes.
Talk to them. Tell them that we are not going to. We know that you are entitled to, but we are only examining this much aspect.
Yes, because some people have come forward, and that's why they have identified some middlemen in this.
You can't pass an omnibus order directing the farmers to make confession statements before you.
No, of course, my lords, I'm not
So
going by that.
Effective investigation report.
No, my lords, I'm not. If that came out that way, that's not what I meant. I'm grateful.
Obliged.
Your Lordship, I'm appearing for the state, Your Lordship. The accused has already been released on bail, Your Lordship, 24 years. And against the co-accused, also the sentence has been suspended, Your Lordship. So, on the, yes, Your Lordship.
Petitioner number 2 only released, my lord. There are 2 accused, my lord, A1 and A2. A1 is standing before your lordship. The name is Karuna. A2 Babu alias Gulam Babu, he was released on 6/6/2018, premature release. So now A1 is granted your lordship bail. He is actually undergone 24 years, 3 months, my lord, as on
We'll
today.
leave it to Your Lordships in this matter.
Have you made any prayer for premature release? A1.
A1.
Have you made a prayer for premature
No.
remission of your case?
No.
Your Lordship, the state shall take instruction in regard to premature release. Yes, Your Lordship. Yes, Your Lordship.
Date may be fixed, my lord.
See, there is nothing in this appeal. Absolutely, if you want to argue, you are most welcome. But you know very well.
Postal witness.
Custody में चला जाएगा.
Proposal for the party. All the appellants are private.
एक को तो कर दिया.
Who is the left appellant number?
Karuna, appellant 1.
Appellant number 1 is permitted to submit an application for remission, for grant of remission. He will do the needful within 1 week. Let the state government take a sympathetic view and pass an appropriate order especially keeping in view the fact that his co-accused has already been released after granting remission. The appropriate order shall be passed within 4 weeks from the date of submission of the application, and a copy of such order shall be placed on record on the next date of hearing. Post the matter on so on so forth.
Oblige, Your Lordship.
Oh, please.
May please, Malad. Malad, this is an application for appointment of an arbitrator. Malad, the petitioner company is an Indian entity and the respondent company is an American entity. They have been served through the prescribed procedure, but they have not entered appearance. Malad, even the office report records that. I'm only requesting that my lords may just appoint an arbitrator. I can show my lords the agreement and the arbitration clause. The agreement starts at page 23.
How much is the dispute? About 40 lakhs. No?
The principal amount claimed is not very large. It's about $42,000. It was a software products and services contract.
Which is the place, because we have to see the local artist, Chennai.
Yes, my lord. Venue is Chennai. And we had suggested one name of an advocate. They suggested another advocate, but we were not ad item. So we are before my lords.
The respondent suggested one advocate, but that was not acceptable to both of you. So this
no,
your advocate, you are suggesting an advocate, not acceptable to them. They are suggesting a name, you are not acceptable. So is it all right if we request some retired High Court judge? But
whatever my lords deem appropriate, because it's a software dispute, my lords may consider anyone else as well. What I'm in my lord's hands, my lords.
All right, we will find out some retired district judge, because it's a very small amount.
Yes, my lords. Great.
All right, arbitrated, we'll find out some fixing now. Next.
Great.
22, my lord, I may inform your lordship, my lord. Both the parties have appointed their arbitrator. It's an international arbitration. Earlier, the arbitrator was appointed by, my lord, by the Honorable Chennai High Court. Then it was held to be, my lord, contrary to the provision. Now, my lord, only thing which I wanted a deference by 2 weeks, my lord. We have just to find out from both the arbitrators have they appointed the third one, or we will then, my lord, then nothing more would be required if they have already agreed for a third arbitrator.
Two submissions to what my friend looks to be slightly different. Lordship sees the earlier order. Lord, we have to appoint our arbitrator. And this court, my lord, we have also requested, these are the instructions. The Lordship has also recorded it, that this court will appoint under 11 a presiding arbitrator. That's one. Now, there are two sets of arbitrations. Lord, this is a section 11 filed by us, not by my friend. What they filed, Madras High Court ultimately held, my lord, you could not have, the High Court could not have appointed the first arbitration, and then it quashed it. It did it in November. We are now in March. No action has been taken by my friend's clients at initiating a fresh arbitration. We have no idea what they're going to do. So this is a second arbitration which we have initiated. We have two prayers. Both of us, he is right. Both of us have, my lord, nominated our arbitrators. If your lordship feels to appoint the presiding, all right.
Finish it by appointing a third arbitrator. What is there?
No, my lord, my instructions are, my lord, that with the apprehension, what happened is earlier, that as per the agreement, both the arbitrators have to appoint the presiding arbitrator. So we are only waiting the instructions from them.
We'll do it for the second arbitration.
No, you have not contacted them from November to today.
It is done now in the third week of February. We both have appointed our each.
No, that is for, my lord, again.
They have a 30 days time to inform us.
My friend is again not.
I have not done anything. I'm only.
No, but what is the problem if you appoint the third arbitrator and then you proceed?
No, that's what the apprehension is, my lord. They want to go as per the agreement. This is my instructions from my friend.
What agreement? You have not been able to honor the agreement.
Simple.
And how?
Kindly have it after a week. Maybe they have done it, or we will ask them if they have not done it.
No, the petitioner is here before us.
Lord, both of us have appointed. Both of us have appointed. The agreement requires them now to deliberate for the third. The 30 days time is provided. 17th of February, we both did it. We are waiting. They have not come. We will approach them and get an answer. If they have not, we'll come back to your lordship. That's all. That is the only request which I made. Kindly call it after 10 days. And we will get back to your lordship. I will inform the solicitor also if anything has happened. My friend can also find out from the arbitrator.
You can grant 1 week time, that's all.
Only as regards the second arbitration. Yes.
Parties
First
seem to
arbitration,
have-
nothing is
the
happened.
Parties seem to
They have not
appointed
taken
their
any action.
respective
Their arbitration, they have not taken any action.
The parties seem to have nominated their respective arbitrators. However, the presiding arbitrator is appointed by both the learned arbitrators. The respondent is accordingly directed to cooperate, to coordinate and cooperate with the petitioner.
Grateful. Publish.
Get the issue resolved before the next date of it.
Yes,
So
deeply.
this matter after 2 weeks and so on. So
Grateful. Deeply obliged.
My lord, service is complete. Respondent has not entered appearance. My lord, it's an section 11 petition. The service is complete. Respondent has not entered appearance. The law ministry has also.
they filed against you arbitration, you are not appearing in Russia. You have filed here, they are not appearing.
No, my lords. Yes, my lords. My lords, there is a stay operating against the respondents from continuing with the arbitration. I had filed a section 9.
For that purpose, you should have gone and tell the arbitrator before the authority.
Informed over there, my lords. However, the order of the Honorable High Court is not being complied with. My lords, the arbitration clause is such. My lords, if I can take your lordship through the arbitration clause, it was amended. Originally, the arbitration clause said that Bombay would have jurisdiction, that is the seat. Subsequently, it was amended. The amended clause is at page number 28, which said that it is on the basis of the party which invokes the arbitration first. I invoked the arbitration. Lords, I can show the letters. I am the one who invoked it first. I also.
Where the Russian Federation arbitrator has proceeded. What is the...
Lords, there was a stay operating and thereafter he has proceeded.
True, but by the amendment of the arbitration clause, the seat of arbitration is to be determined on the basis of the applicant's choice. Now, the applicant in Russia is the respondent here, and there the arbitrator has already entered the arbitration. So, will it not be a conflict?
My lords, now there will be a difficulty. The arbitrator over there has proceeded with the matter, my lords, in spite of a stay adjudicated. It is only in respect of the claim of the respondent. I had submitted myself to the jurisdiction of the Honorable High Court and I was over here in time, prior in time, my lords. Now, my lords, my claim do not even lie over there, my lords. And my lords, may please see the order of the Honorable High Court under section 9, my lords. The courts in Russia has proceeded in teeth. Today, my lords, those proceedings are nullity as far as India is concerned.
In the 9 where anti-arbitration injunction you have obtained, you move an application appropriate there. They will appear, if they appear there, it's all right. If they don't appear, the court will pass an appropriate order.
Over there also, my lords, they did not appear.
Therefore, let that court pass an appropriate order. After the 9 injunction, probably, what else can be done?
My lords, 9.
Declare the proceeding null and void.
My lords, 9 injunction.
Today, as on date, the parallel proceedings are going on. If we of today appoint an arbitrator and initiate proceeding, it is something order which will be defined by them. Then why should we pass an order which is capable of being defined?
My lords, can I answer? What is pending in Russia? If at all, I understand the difficulty. If I can just present a solution, my lords. What is pending?
That they have initiated here.
My lords, the matter was pending. Service was that. That's why, my lords, all this has transpired. However, my lords, what is pending over there is not my claim.
Court which has granted injunction, if on facts found, if the court finds that yes, they have appointed arbitration or they have started arbitrating after the injunction was granted, the court will declare those proceedings null and void. Then the law will take its own course. Today, the proceedings are pending. You are relying upon an injunction order, which is also not a final order. The court might ultimately, it's a question of fact that did they started arbitrating before you obtained injunction or after that?
Lords, may kindly have the injunction order. It clarifies that.
You are after us to assume that role. That is a finding to be returned by the injuncting court.
It's already mentioned, my lords, because my invocation of the arbitration is when I send the notice under section 21. It says my notice is prior in time. And the respondent has thereafter, my lords, in view of the clause, sent a subsequent notice. In view of this, the injunction is granted in my favor. Now, I follow your lordship's question, but my remedy in section 9 is limited, my lords. In section 9, I cannot seek for setting aside a foreign award. So while, my lords, I can say that
it may not be set aside by the court can always declare the proceedings being contrary to the order of injunction. And such proceeding,
I bow down, my lords. But when, my lords, for appointment of arbitrator, I have to come before your lordships only.
Only after that, when the court declared that yes, their appointment of arbitration or initiation of those proceedings is illegal and contrary to an order of injunction. Once the court declared that proceeding are null and void or illegal, then you have a right to seek appointment.
In that case, my lord, since it has transpired while the matter was pending over here, my lords may allow me time to pursue in section 9 and keep the petition pending, my lords. Once the section 9, my lords, my lords may kindly allow me this liberty.
Why don't you file a fresh petition after 9? We will grant you liberty.
My lords, will immediately apply to the section 9. My lords, I'm only asking for a month's time, my lords. I'll apply in the section 9 court. Because, my lords, my date of section 11 and everything, my lords, because timeline is important over here.
You can grant you time. Meanwhile, he wants to pursue the anti-arbitration injunction suit pending before the Bombay High Court. Then suppose this matter after 8 weeks on solicited.
My lords are listing it after obliged.
Item 24, my lords, is another section 11 petition. Because the order of 9th October 2025 records that service is complete. Because thereafter the matter was listed on 31st of October. Where my lord said we'll wait for 4 more weeks for them to enter appearance if they wish. The matter is coming up now, my lords, after October. Nobody has entered appearance, my lords. And the order records I've served everybody.
Then?
I'm sorry, my lords. Lords, any arbitrator may now be appointed, my lords. They have been duly served. Sorry, my lords.
How much is your claim?
Claim, my lords, I will not be able to quantify because it depends on their investments, because the value of the companies. But my lords, if I had to, based on the existing, my lords, the record which is in public domain, I would say, my lords, around 4 to 5 crores. With any retired honorable judge of the Karnataka High Court, because it's a sole arbitrator to be held, my lords, in Bengaluru. So any retired judge of Honorable Karnataka High Court, any advocate, learned senior advocate of this Honorable Court, so I leave it to my lords.
All right, we will appoint some senior advocate just for your paper satisfaction. Otherwise, you will get nothing. And initially, you will bear the entire burden.
If we can request for 4th schedule fee to be applicable, if we can request for schedule 4.
They are not appearing, so you will have to bear the burden initially. Then
very well, my lords, I leave it to my lords.
What is passed in favor, of course.
That's right. Grateful, my lords.
My lords, this is for substitution of arbitrator. As the earlier erstwhile arbitrator, he has withdrawn from the arbitration.
The reason he withdrew was just have a look at 2 pages. What sort of allegations they made against the retired High Court judge?
My lords, if I may submit.
The allegations they made, my lords, he had no other option but to withdraw. Please have a look.
My lords, if I may submit, I'll give a background of it. The withdrawal has happened on account of a letter submitted by the claimant. Now, the claimant is a international company which is based in Guinea. And my lords, in this matter, we just wrote a letter to demonstrate our hardship, the hardships which we were facing. We wanted to bring on record certain additional documents. The trial was not initiated. The application was allowed. In spite of that, 2.5 lakh cost was imposed on us. The letter, if
does not mean that the arbitrator is having any bias or anything, but then the point is that the learned arbitrator himself has now kind of recused.
Only reason I just want to, who would want to continue with this conduct? Please have a look at 4 pages, then I leave it to my lords, my lords.
Because there is no allegation as against the
I have no
arbitrator.
other option but to withdraw from this arbitration.
Because
Just see the
can be
tone of the
examined.
letter, my lords.
The letter can be examined. There is no allegation as against the learned arbitrator.
The retired High Court, please have a
It
look
was only we were only demonstrating the high-handedness of the respondent.
Please.
All right, now you will have to deposit the initial expenses of the arbitrator.
Lords, we have paid the complete fees.
To the arbitrator against whom you made allegation and you forced him to recuse. Right? Now you want a new arbitrator. We will give you. But then you must have the pain of the cost, no? So that you realize that if you make again set of new allegations, you will think 100 times.
Lords, the letter can be examined.
It is there on record.
There is no allegation as against the arbitrator. Because the respondent can demonstrate a single line wherein we have stated anything as against the learned arbitrator. And at the end of the letter, we have just written that.
No claim. So first you will deposit and then we will see that the learned arbitrator will take a call.
Deposit to whom, my lords?
To the arbitrator fee and everything.
My lords, with respect to payment of the fees, we have always been bona fide. Even before the learned arbitrator, he withdrew from the office, we paid the fees.
Do you want to argue that we recover the amount now from the previous arbitrator?
I do not, my lords. My lords, I'm just demonstrating that we are bona fide.
So,
and the letter can be examined, my lords.
Appoint a new arbitrator. Is he not entitled to fee?
Definitely, my lords. He's entitled to the fee.
Who will pay?
My lords, as per the act, both the parties can share.
Party will pay. So initially you will pay, and we will then leave it to the learned arbitrator that he will determine at an appropriate stage that how much they are liable to.
My lords, all I'm requesting that it should be done as
arbitrator has disappeared from the scene thanks to your application.
My lords, that was not an application. It was just a letter written.
And
we did not seek.
Can we see that letter, my lords? And I leave it.
My lords,
can we see that letter?
You can examine. My lords can examine the letter.
Yes.
There is no allegation as against the arbitrator. It's on page. It's
But my
beginning
lords,
from page
just-
72.
Please have a look at first 71, my lords. This is the letter of the arbitrator, my lords.
My lords,
Let me just complete. Page 71, my lords.
The arbitrator holds that the letter is bordering on contempt.
My lords, the letter on the date of hearing, I was present. The arbitrator just asked us whether we want to withdraw the letter. We said that the letter is not to disrespect the arbitrator, the arbitral tribunal, and there was no discussion about the letter at any point of time. That's why, my lords, I am before my lords. And this letter can be examined. This begins from page 72. There is not a single allegation we have made as against the arbitral tribunal.
Nothing could be more than an allegation of bias in the conducting of the arbitral
My
tribunal.
lords, we have not said that the arbitrator has been acting in a biased manner.
Permitted to be overbearing. Your counsel was not given adequate opportunity. Costs were not being imposed upon them. Costs were being imposed upon you. According to you, there was no equality of arms in that.
My lords, the facts can be seen. We are a company, small company from Guinea.
Steps to set aside award, if any.
Please see
on the
74,
ground
my
of
lords. Allegations they made, my lords.
Fair and biased arbitration.
My lords, we have not stated. We have just requested the tribunal that the high-handedness of the respondent can be seen.
My lords, just two submissions. Just have a look at this letter, page 74, 75. Either the same arbitrator can be requested to continue, my lords. If this conduct, no one will come.
Lawyer changed here. It changed.
I am suffering
Yes.
because of them.
My lords, they might make such allegation against the new arbitrator also. Please see 74, 78. These
My lords,
allegations.
there are no allegations. We were just requesting that it should be taken in right perspective.
Please see 74, my lords. Please see 74. The letter which they sent to the arbitrator. 74 at the top.
We have seen that letter.
Yes.
We are satisfied that this letter was written only with the solitary purpose of
My lords,
forcing him to read.
my lords, there is no. My lords, if 74, if I read the first.
My lords.
My lords, if I read the.
We are allowing your petition. We are appointing a new arbitrator, a person, a former judge of the High Court with having chartered accountancy background because of your claims, so many invoices, this and that. But entire cost will be initially borne by you, subject to the award which the arbitrator will pass, and if they are liable to, then cost factor will go to them also.
Should not let the same arbitrator be allowed to continue with this allegation they are making as the arbitrator, my lords. The reason is
Will not be.
That will be very embarrassing for you.
My lords,
in that case, my lord, let it be continued from the stage the arbitration was, my lords. Why should otherwise? Yes.
Definitely.
Yes, my lords, just observe in the order.
my lords, just a request, my lords. My lords, I have already been burdened. I'm a very small company from Guinea. The arbitration is international because I come from outside.
Your claim is now, you say, my claim has now multiplied to 17 odd crores. If you want your claim to be adjudicated, you will have to deposit the fee, the arbitration cost. Otherwise, you are responsible for it, and what we can do.
My lords, it will be very prejudicial to the rights of my client, my lords.
If it will be like.
My lords, my lords, I can demonstrate from the letter that none of the contents written, there was no content as against the
You
arbitrator.
are very well prepared, but we have also read that letter. No judge will continue with the proceeding if he receives this kind of letter. It is good enough for any judge to feel embarrassed.
Even fees they had agreed, I can show from the documents, my lords. They did not, they filed documents that cost.
Next item.
My lords, may just observe in the order, my lords, that it will be continued from the stage the arbitration was. My lords. It would be continued from the stage the arbitration was. It was at the stage of evidence, my lords.
So let me leave it to the new arbitrator.
Because this will burden upon us.
My lords, otherwise it will burden us, my lords.
We'll see that how soon they make allegation against the new one. Let's wait for that.
My lords, we have appointed the arbitrator. The intent was never to put any allegation as against the arbitrator. The letter, there is in the entire reply, the respondent has been unable to bring on record what is the allegation we have made in that letter.
This time you have an arbitrator not appointed by you, appointed by the court. So be careful.
And this was their choice. And this arbitrator was also their choice, my lords. We had agreed to that arbitrator. This was their choice, arbitrator.
So he is one of the finest persons.
Yes, and it was their choice which we agreed, my lords. If my lords can just observe, it will be continued from that stage, my lord.
Item 26.
Let it be from that stage.
My lords just observe in the order, they will be continued from that stage, my lord.
It says, as per schedule, it begins from the stage where the next arbitrator starts.
They delayed it, my lord, they did not file documents.
My lords, this is what I wanted to argue, my lords. My lords, throughout the arbitral proceedings, my lords, kindly hear me. This is the allegation they have been.
Don't get agitated, please. Don't get. We are accepting your claim. We are appointing an arbitrator. So, when you argue the case, this year never allowed to operate. Only that's all. In the court.
I was just trying to impress upon my lords that why I'm submitting, what I'm submitting, why I'm submitting.
You have allowed your petition. You wanted a new arbitrator, we have appointed.
Much obliged, my lords. I'm
much obliged. The learned arbitrator to decide the claim expeditiously.
Much obliged.
We are not referring to any other thing which may even remotely cause prejudice against your claim or their claim. We will make sure.
My lords, we are the only claimant. They are just the respondents.
Today, my problem is they did not file documents. They are now going to get all the opportunities again, my lords.
My lords, even before the trial began, we filed.
Arbitrator also.
Very well, my lords.
Next item. अरे उधर क्यों देख रहे हो तुम केस शुरू करो अगला.
My lords, I am for the applicant in this matter. My lords, it's a section 11 petition for appointment of arbitrator. The respondent is based an entity based in Hong Kong, my lords. My lords, we try to serve them through Dusty as per last order, my lords, but however, the custom department of Hong Kong has held our parcel and it was returned to us, my lords, with this finding, my lords. And as per last order, my lords, notice was also issued through Ministry of Law and Justice, my lord, but the Lords, may kindly grant me one more opportunity to serve them through Dusty and may kindly call for the report from the Ministry of Law and Justice since they have not supplied the report of service till date.
No. Who wants to go with Dusty notice? Would you like to serve them?
Yes, my lords. We would like to serve them through registered post with acknowledgement due, my lords, as per last order, my lords.
Mr. Prathi, file an application for substituted service.
Oblige, my lords, on the last date, my lords, on the last order, my lords, it was reflected that we will.
This problem body online pe na. As per the office report, the respondents seem to have not been served. Liberty is granted to the petitioner to serve the respondents through substituted service. Post the matter on so date after 6 weeks.
Please, Willows. In item 27, this is an international commercial arbitration. Willows, this is a petition for appointment of an arbitrator in international commercial arbitration. The respondent is a German entity. They've been served and the wakalat has also been filed on 3rd of June 2015. The agreement, my lords, the entire cause of action.
What is the service position?
Service is complete, my lords.
We appear for, my lords, we appear for the respondent, my lord.
Oh, you are appearing?
My lords, we are appearing.
Ready or you
My lords may proceed to appoint the arbitrator. My lords, we have a lot to say on the merits of the claim, but we cannot be disputing the appointment of the arbitrator because clearly there's a dispute between the parties on the claim that's being raised. There is no provision of a seat in the arbitration clause, but I would imagine the petitioner is seeking to create.
Just a minute, madam, just a minute. You have also.
Lords, the claim amount is
You appears to be an AI trained counsel.
My lords.
Now you understand. Thank you very much. You tell us that where is the seat of the arbitration and how much is the claim? Whom do you suggest anything? Any name from both sides?
My lords, the claim amount approximately from the claimant side is about 50,000 USD. 50,000 USD from the petitioner's side.
My lords, we will also be having a counterclaim, my lords.
Fluctuating every day.
Approximately 50
It all depends what will happen tomorrow there in
50 lakhs in Indian rupees, my lords.
My lords, we will also have a counterclaim, my lord. We will also have a counterclaim, my lords, of approximately the same.
Well, in law you are entitled to. There is no difficulty. You can always.
My lords, I was placing that for my lord's consideration while appointing the
Where
arbitrator.
the arbitration to be conducted? Which place?
In Bangalore, my lords.
In Bangalore.
The seat of arbitration or the venue is not specified in the contract, but the entire cause of action occurred in Bangalore. Therefore, the seat.
All right, let us ask the young lady, where do you want to be arbitration to be conducted?
My lords, the cause of action is in Bangalore. However, my lords, I'll be in my lords' hands if they would like to, given that there is no seat or venue. And the position of law is that it would be where there is cause of action. So I will also concede to the arbitration being in Bangalore, my lords.
At Bangalore.
My lords.
All right, we will appoint some former judge.
Please, I'm grateful.
Much obliged, my lords.
May I make a request that the arbitration be conducted under the aegis of the Arbitration Conciliation Center, Bangalore. I have the list of panel of arbitrators also of the center. If that may be possible.
Who is Bangalore?
My lords, there's an Arbitration and Conciliation Center, Bangalore, under the aegis of the High Court.
No, run by whom?
My lords, it's under the aegis of the High Court. Under the aegis of the High Court.
High Court, then we can.
My lords, then may I be permitted to.
Who is the Chief Justice of the High Court to nominate?
My lords, may I be permitted to give panel of arbitrators for
the list of the.
My lords, this may be only considered as a proposal by the petitioner, my lords. There is nothing binding on us. As per the arbitration clause, my lords, there is no institution or center. We're in my lord's hands, and it may only be considered as a request or recommendation by the petitioner.
It's only a ready-made list for our assistance prepared by
my
the
lords.
That's all.
Much obliged, my lords.
You also know it very well. The only thing is from here we will get the contact number. That's all. Nothing
Much obliged, my lords. Much obliged.
Lordship. आपके पास भी होगा.
Lordship raises. Lord, this is also a petition for appointment of arbitrator. Lord, the clause, Lordship, is that provides for Northern Railway.
What about service?
Lord, they have served. They have filed a reply also.
They have filed reply also.
Yes.
The appearing.
Lord, the case is squarely
covered. That railway. Oh, the railway matter.
Railway matter covered by court.
Saying that their officers panel.
Yes, Lord.
That is gone. Who is appealing for any idea?
Did we see that?
Say counsel for the respondent railway is not present. Before we impose exemplary course from The one opportunity is granted to the learned counsel to enter appearance and assist the court. Post the matter on Sunday date.
Wait, please. This is coming after notice.
Item
They're all
20.
composite agreements and the counter has come.
All petitions broadly are on the same.
My lords,
No,
item
they have not
29,
approved
I'm
about the
requesting for a
appointment.
short adjournment because the AOR has changed yesterday. I'm requesting for a short accommodation in this matter.
What do you do?
The counter has been filed.
The counter.
The respondent is opposing the invocation.
No, the
and
counter
I may be
is
given-
predominantly on merits. They don't say anything about the existence of an arbitration also.
There is a clause in arbitration.
My lords, if you give me one opportunity, any short date, I will come and argue the matter. We've just been appointed yesterday. I'm requesting, this matter was to come up on the 7th as per the status. It's come up today. I'm requesting for one short adjournment.
Then be ready for costs also. That is the only way. Because there is an arbitration clause. Whatever argument on earth you want to argue, argue before the arbitrator. We are not concerned about that.
Your Lordship, there has been wrongful invocation in the matter. That's the case of the response.
Wrongful invocation, you will argue before the arbitrator. They say it is not maintained.
Your Lordship, may give me one short opportunity.
Then you deposit the cost with us.
I'm in your Lordship's hands.
No, nothing like in our hand. We are all at your mercy.
Your Lordship,
because there is an arbitration clause, you are not disputing it. You say it has been prematurely invoked. All right. Argue before the arbitrator.
There was a full and final settlement in the matter, is what I've been informed. Your Lordship, may give me one opportunity.
The settlement produced before the arbitrator. Let the cost be imposed on them.
Your Lordship, may kindly accommodate me by 1 week or any other short date convenient to your Lordships.
This has been pending since last year. That
As per the
counter every matter. Where at is, they admit the composite transaction and existence.
Decided as a preliminary.
In any event, it has to go. Very well.
Heavy, but they remain incomplete, so we have to accommodate.
Very well.
Deeply obliged.
On 10th April?
Deeply obliged.
As your Lordship please. Obliged.
Lordship, yes, of all, I apologize. Lordship, it was served through through email, but due to communication gap, I could not file the affidavit of service.
Counsel for the petitioner seek more time to
file the affidavit of service. It is filed through email. It has been served through email.
But have you served?
Yes, it's served on 18th of July last year.
Counsel for the petitioner seeks and granted 1 week time to file an
Affidavit of service, Lordship.
Post the matter on Sunday, 10th April को लगा. तो बचे मैटर जो हैं इनको 10th अप्रैल को लगा फ्राइडे है तो निकल जाएंगे या उसको लगा दो फिर मंडे की तो एक तो 10th को लगा गया बाकी 13th उसको लगा दो मंडे को 13th.
Lords, on item 31, the respondents have been served on the local addresses. But and so the respondents have been served on the local addresses.
Domestic arbitration.
International arbitration, my lords. International arbitration, my lords. Yes, my lords. The entities of Singapore.
Singapore.
Yes, yes.
Anyone appealing?
No, my lords.
Service complete.
Service on the local addresses is complete, my lords. Insofar as the registered.
This will itself will be a good ground to set aside everything.
Yes, my lords. The Ministry of Law and Justice has said that they require about 4 months, my lords.
Respondent number 1 is yet to be served. Liberty is granted to the petitioner to effect service through substituted service.
My lords, substitute service in Singapore, my lords.
Substituted service. Issue of notice.
Very well.
We are permitting you.
Very well. Grateful.
Post on solicitor. Yeah, 6 weeks के बाद. चलिए भाई जल्दी करिए कुछ खाना भी खाना के बाद. Item 32.
Please, Manoj, this is coming up after notice, Manoj. There's an arbitration clause. It's an international agreement, Manoj. The seat is in Bombay, my lords. The arbitration claim is about 14 to 15 crores as per the exchange rate as on date, my lords. On the
What had fallen was from this honorable court on an earlier occasion is they can suggest one name of an arbitrator, we can suggest one, and then my lords may appoint a president.
Bombay Justice Wazifdar is the best person.
No, that is, he is their appointee.
Their appointee. You don't want.
Or my lords may appoint anybody.
Justice Bhonsle.
Justice
Bhonsle, former Chief Justice Allahabad High Court.
Yes.
Say, though the learned counsel for the parties are having difference of opinion with respect to the choice of the learned arbitrator, on being persuaded, they fairly agree that Justice Bhosle का पूरा नाम लिख देना, Dilip Bhosle शायद.
Justice
Dilip S. Bhosle, former Chief Justice Allahabad High Court, is hereby appointed as the sole arbitrator. The party shall appear before the learned arbitrator on so and so date. Standard डाल देना भैया.
Grateful.
Next.
My lords, I'm appearing for the petitioner. This is a Section 11 application, my lords. The dispute relates to wrongful termination of...
Dispute is alright, what about service? Dispute we are not to hear.
My lords, the respondent has been evading service. He has returned the packages.
Let's go by substituted service. Learned counsel for the petitioner seeks and permitted to effect service of the respondent through substituted service. Post the matter after 6 weeks on so and so date. Next. 34.
34, Your Lordship.
Lords, in 34, my lords, this is also an international arbitration seeking appointment of an arbitrator. My lords, there is an arbitration agreement. There is no
service, sir.
Please, Your Lordship, I'm taking an objection here because there's a serious objection on fraud.
Lord, this is all on the merits. This can be argued before the arbitrator.
No.
There is no dispute insofar as an existence of an arbitration agreement.
I'm only saying, even at this Section 11 stage, where there is a clear evidence of fraud on the face of the record, serious fraud, which goes to the bottom of the clause and to the proceedings.
The arbitrator will examine it. It is a question of fact. Fraud is always a question of fact.
Of course, Your Lordships may always relegate me to the arbitrator. However, my lords, I'm only asking to be heard for a few minutes. Allow me to tell Your Lordship why I'm saying there's fraud. There's fraud.
What is the use of? Because we are not going to mention anything in the order.
Please, Your Lordship.
We can't write against them to say that there seems to be some merit in the allegation of fraud. We can't write against you that fraud is only an excuse or a ruse only to avoid arbitration. We can't say both the things.
No, my lord, because then Your Lordships have actually accepted entirely the 11th petition without testing it. Even on the very, and I must admit, my lord, it's a very small in limine determination that Your Lordships would
Is
make.
your signature forged in the arbitration agreement?
No, my lords.
Then the existence of the agreement is admitted.
My lords, in fact, the reply he says that we have terminated.
Whether the shares which is subject to the arbitration or the dispute were actually transferred by them or you had misappropriated are issues which you say are absolutely an afterthought and raised by way of wild allegations.
I would only say this complaint is now pending before SEBI. SEBI is otherwise looking also into these fraudulent.
It's a different issue altogether.
So, what happens, my lord, what happens here is that a lie is told.
Not to listen what happens because we can't mention anything.
Your Lordship may just consider, because actually it's a very simple long con which is played. What happens is there are elderly NRIs outside India who are told that since you left India, you must have left lots of securities behind. Those securities are now turned into millions. And therefore, they enter into these agreements with them to say, please find my securities. They come and give you the contents of what is your own wallet. It's like a man coming to me and telling me you've lost your wallet, it's in your pants. And that to that extent, my lord, then they raise a bill. Then they take it in Section 9. What happens is in Section 9, if they get a stay or something, in settlement.
Contract Act.
Please, Your Lordship.
Will take care of your defense.
Please, my lords.
If it is against public policy, if it is on the basis of false representation or fraud, it's an unexecutable claim. That would be decided by the arbitrator.
On merits, my lord, I'm very confident I will succeed. However, in limine, even today, to put it to an arbitration is the abuse of profit engineered by them. That's what I'm saying.
You want to have some, because amount is hardly about 15 lakhs.
If Your Lordships will only permit me.
12 lakhs and 14
I
lakhs.
also want to produce.
14 plus 8.
Please, my lords.
It can be 15 plus 8 if you add plus.
Please, my lords.
So
My lords may refer to the DIAC, Delhi International. If my lords would. Delhi Arbitration Center.
We don't give that much importance to anyone. If you have a list of the arbitrators from there, you give us, we will appoint someone.
My lords, we have in fact mentioned an arbitrator at page number 40, my lords, in our notice invoking arbitrator.
Unacceptable because this is one of many arbitrators.
Find out from the list of the Delhi arbitrators.
I would only say, my lord, that I can give Your Lordships a list of such disputes which have been engineered, which are a fraudulent scheme. It is the dispute itself which is part of the fraud.
All right, we'll appoint someone.
I'm grateful.
Would my lords only consider having the arbitration at the Delhi International Arbitration Center of the High Court, my lords?
Arbitration, we will see who's to be appointed.
Please, my lords. And the fourth schedule, my lords, as per payments as per the fourth schedule, my lords. The fees as per the fourth.
We will keep your total claim in mind.
Please, my lords.
It's a very small.
Deeply
claim,
obliged, my lords.
The point is the claims are small, so they force them into a settlement. That is why.
Item 35.
Deeply obliged.
Obliged.
My lords, I beg to appear in item number 35.
Is to be contentious.
My lords, we seek to withdraw this petition.
You want to withdraw?
Yes, my lords.
Learned counsel for the petitioner seeks and permit you to withdraw this petition. Dismissal.
Obliged.
Thank you very much for asking it. Madam Ashwarya, we will come after 15 minutes. 15 minutes.
Please.
Thank you.